Hello everyone, today's topic is settlement of disputes in international law. To begin with the topic, we'll introduce the topic. Dispute settlement in international law is a vital mechanism for resolving conflicts among sovereign states as nations navigate intricate global relations. Disagreement arise, necessitating structured framework for resolution rooted in diplomatic negotiation, arbitration, and international courts. These mechanisms evolved to address contemporary challenge. This concise exploration examines the historical context, contemporary challenges, and the diverse array of mechanisms employed, emphasizing their pivotal role in upholding the rule of law, fostering ability, and promoting peaceful coexistence among nations. Understanding dispute settlement in international law is fundamental for navigating the complexities of state interaction and building a just international order. Moving forward with the historical evolution of dispute settlement. The roots of international dispute settlement can be traced back to diplomatic negotiation and bilateral treaties. Historically, states relied on diplomatic channels to resolve conflicts through dialogues and negotiation. However, as the complexity of international relations grew, the need for more formalized mechanism became evident. Arbitration emerged as a popular method in the late 19th and early 20th centuries, allowing states to submit their disputes to impartial third party for binding decision. Next, what are the contemporary challenges? In the modern era, the challenges facing international dispute settlement have evolved. Complex geopolitical issues, differing legal system, and the rise of non-state actors have added layers of complexity to conflict resolution. Additionally, the effectiveness of dispute settlement mechanism is contingent upon state consent, and instances of non-compliance or selective participation pose challenges to their enforceability. Furthermore, the increasing use of economic sanctions, cyber warfare, and unconventional tactics in international relations has challenged traditional dispute settlement framework, prompting a need for adaptation and innovation in the field. Moving forward to the diverse mechanism in international dispute settlement. International law provides a range of mechanisms for dispute settlement. Bilateral negotiation and mediation remains essential tools, allowing states to address issues directly. Regional organizations such as the European Court of Justice or the African Court on Human and People's Rights offer specialized forum for dispute resolution within specific geographical context. Global institutions like International Court of Justice or ICJ plays a pivotal role in adjudicating disputes between states based on consent. Additionally, international treaties and conventions often include dispute resolution provisions, creating specific mechanisms for addressing disagreement arising for treaty obligations. What are the implications for global peace and security? The effective functioning of dispute settlement mechanism contributes to global peace and security by preventing the escalation of conflicts into armed confrontation. Compliances with international law and respect for dispute resolution process enhance the credibility of the international legal system, fostering an environment conducive to cooperation and diplomatic solution. In conclusion, the field of dispute settlement in international law is dynamic, adapting to historical developments and contemporary challenges. Now, what are the types of dispute settlement mechanism in international law? We'll discuss 10 types. The first one being the negotiation. Negotiation is a direct discussion between state to reach a mutually acceptable agreements without the involvement of third party. Its characteristics are that it is a flexible and informal discussion and relies on diplomatic skill. Second is mediation. Mediation involves a neutral third party facilitating negotiation between disputing parties to help them reach a consensus. Third one is arbitration. Arbitration is a formal process where disputing parties submit their case to an impartial third party, which could be arbitrator or panel, whose decision is binding. Fourth one is adjudication by international courts and tribunal. Disputes are brought before international courts such as ICJ for binding decision. It requires the consent of both the parties and involves legal judgment. Fifth one is regional dispute settlement mechanism. Specialized mechanism within regional organization like the European Court of Justice or the Inter-American Court of Human Rights. These are tailored to address disputes specific to a particular region. Next is diplomatic protection. A state acts on behalf of its national whose rights have been violated by another state, seeking resolution through diplomatic means. It involves diplomatic interventions and negotiation. Seventh is conciliation. Conciliation is a process where a third party, the conciliator, assists in resolving dispute by making non-binding recommendation. It focuses on finding common ground without posing a binding decision. Eighth is expert determination. It involves appointing expert to assess technical or scientific issues and provide a non-binding opinion to assist in dispute resolution. Second last is state to state consultations. It is an informal discussion between states to address disagreements and find amicable solution. It is a non-binding and relies on diplomatic dialogues. The last one is dispute resolution clauses in treaties. Many international agreements include clauses specifying the method for resolving dispute arising from the treaty. It provides a predetermined framework for dispute resolution. Now, with the end of the topic, we sum up the topic. So, international conflict settlement provides a dynamic range of process distinguished by historical evolution and modern difficulties. These procedures, which range from diplomatic talks to arbitration and adjudication, adjust to the changing circumstances of international relations. Diverse system guarantee flexibility even in the face of persistent obstacles such as geopolitical complexes. By preventing conflict escalations, encouraging legal compliance, and providing diplomatic avenues, dispute settlement mechanisms play a pivotal role in fostering a cooperative and rule-based international environment. As the world progresses, refining these tools remain crucial for navigating the intricacies